What's up, everybody? Back at it here on vacation. Got my old Calvary Letterman jacket on from high school. You can see Peter, whoops, this side, Peter Tragos football. My first letter among others. We could talk about that another time. Still fits me great. It was a little big in high school, but it still fits me great now. We're here, we're hanging out. It's freezing. There's snow on the ground, actually. Probably more like frost, but to a Florida boy, we call it snow. My kids call it snow. So that's been fun. I've got my dad who's going to join me today, and we're going to talk about Brian Kohberger's secret or sealed appeal regarding the grand jury indictment that they want to dismiss that Judge has denied. We'll talk about who the appeal goes up to, why it's sealed, what it means, what does interlocutory mean versus just a regular appeal. A lot of people had questions about that. We'll talk about whether or not it's going to delay the case, how this could affect the scheduling order that the state wants the trial to go in the summer of 2024, all that and more with my dad. And then I'm going to get his thoughts on the Kings Road demolition. You've heard from me, you've heard from a lot of people. We'll get a little different perspective from his point of view near the end of the video. So make sure you get your questions in the comments. We'll take a look at them later. We'll see if we can answer them later on other videos or in the comments later. We'll go in there and try to answer as many as we can. Hit that like button if you guys haven't already. And make sure you subscribe because we're going to continue to follow this case, and all of the questions you all have on it are important to us as well. So I'm going to bring my dad in, and we are going to take a look at this appeal. What's up, Dad?
Hey, good morning.
No, I don't want to do it that way. Let's do it this way. Okay.
Okay.
So here we go.
Okay.
Good morning. Motion to seal defendant's motion for interlocutory. Comes now. Brian Kohberger, by and through his attorney, Ann C. Taylor, public defender, and hereby moves the court for an order to seal the defendant's motion to reconsider orders denying motion to dismiss indictment, and in the alternative for permission to appeal from interlocutory orders and a stay of proceedings filed with the court on December 21st, 2023. And then there's another document where the court granted this motion. So a couple things to break down. We have read through already the motion to dismiss the indictment based on prosecutorial misconduct, not giving exculpatory evidence to the grand jury, not presenting it the right way, presenting the wrong burden of proof, all sorts of arguments. So to start out, let's talk about what is an interlocutory appeal.
Do me a favor, scroll down. Can you scroll down a little bit? I want to see where that was filed.
I don't know what you mean.
What
you mean this way?
I want to see what court it was filed
Second judicial, in the district court. So it goes up to judge first.
Okay.
And then it will go up further if judge denies it. Usually the trial judge that's already made his decision denying these will deny this, but it still could go up. But what's interlocutory mean?
Okay. Interlocutory means it's an appeal from an order that is not a final judgment. So for instance, we all know criminal case, jury comes back with a verdict. There's a sentencing after the verdict. That's final. That's a final judgment. Things that happen before the jury comes back, things that happen before the sentencing, those aren't final. So normally you would wait, put this all into an appeal that happens after the final judgment. That's a normal appeal after the final judgment. Again, and you can appeal everything that happened during the case after the final judgment. Interlocutory means something happened during the course of the case, before the case is final, that an appellate court needs to rule on. That something happened and it's so important that it can't wait until a judgment from the jury, a verdict from the jury. It can't wait until the normal appellate process. So that's why if you look at the wording, they use a little different wording in Idaho. They call it an appeal by permission, but it's the same thing. It's an interlocutory appeal, and they're asking the appellate court, the Supreme Court, to give them permission to file an appeal, even though they don't have a final judgment. So they're asking for an exception to the normal course.
And so we've seen appeals in cases go all the way back to motions to suppress and motions to dismiss and things like this that are also included sometimes in the appellate process. But sometimes they feel like something is so important, the case would completely go away if they were to win this. Obviously, the state would be able to refile, but they feel like it's important enough to halt everything, do it right now. It happens in our civil cases as well. It's really annoying because it can pause the whole process. It can create a stay. So let's talk about that. What does it mean if they were to get this granted and a higher court, even if it's not judge, but a higher court decides we are going to stop, we are going to look at this, we are going to make sure they got it right at the trial court level. What does that mean as far as a pause in the case or a delay in the case?
Well, Idaho does it a little bit differently than some other courts. In Idaho, you file this alternative or for permission for an appeal. Then the Supreme Court has to give you permission to appeal the case. There is not a stay just because you file for permission.
Right.
Only if the court says we're going to grant you permission to file this appeal, then there is a stay, and that process is just like the normal appellate rules go into effect. This is the way it's Idaho. Now, example, the federal court, you file a interlocutory appeal in an appellate court. Once you file the interlocutory appeal, it automatically stays what's going down in the lower court, what's happening there. I've had cases, one real interesting one where we had a motion. The court initially denied our motion. Court changed its mind, granted our motion. And then at that point, we said, this is double jeopardy because we were put into jeopardy by what the court did, and I wanted to appeal it to the 11th Circuit Court of Appeals. As soon as I filed that appeal, an interlocutory appeal, it stopped everything. It stopped the new trial from even starting in the lower court. The government didn't like that because we had all these motions, but we had a great judge who knew the rules and said, look, forget it. Don't even give me a call until this is decided. The judge wouldn't do anything until the appellate court decided the interlocutory appeal. Idaho is different. Idaho, there is no stay strictly because you file for the interlocutory for permission. It only happens if the court grants it. In Idaho, interestingly enough, I looked it up. 2021, 2022, the court only granted 5 permissions for interlocutory appeal. It happens very rarely. And there's a lot of articles about how rare this is in Idaho. Very tough for an Idaho situation because they also have some rules about interlocutory appeals in Idaho. I don't know if you want me to go explain that now, but they also have specifically. Go ahead.
The point is, at this point, they're filing for a higher court eventually, because Judge is probably going to deny this, but for a higher court to say, yes, you can appeal this, we'll pause the case, we'll stay the case. So usually in that type of a situation, like here, when we're talking about it, it could have no merit at all, but it could still create a stay. It could still create a pause. In Idaho, you would think if it gets there and they allow a stay and they allow a pause, that means there is some merit potentially to this appellate issue that they want to pause the case and do an interlocutory appeal.
Well, there's only 2 ways to do it in Idaho too, which is why it's so rare. One is public importance, and the other is a issue of first impression, which means that it's a unique legal issue that's being presented that needs to be decided before the court proceeds, and that there's of great public importance for them to decide this before the case proceeds. That's why it's so rare that this happens in Idaho.
So chances that you think this actually ends up happening and they stay the case with an interlocutory appeal?
Slim and none.
Yeah, I think there's almost no chance
so.
This is going to go up. It wasn't that. I mean, here's the bigger issue too, is we don't know. This is sealed. It's quote unquote secret. It's confidential because it's dealing with the grand jury, the proceedings, the things that happen in the grand jury information, the evidence presented to the grand jury. All of those processes and procedures are secret. The defense has gotten them. The judge has seen them because we know they've ordered the transcripts, but we don't know when we're guessing about the merit of what happened in the grand jury. Obviously, we don't know the specifics of it, but Judge pretty summarily just denied everything. It didn't seem like it was really a consideration from what we know of the case. They probably had enough for probable cause to present to the grand jury. The exculpatory evidence that they keep mentioning that was not presented, we don't know exactly what that is. It could be potential DNA testing or things like that that are arguments the defense wants to make, but not necessarily exculpatory evidence that the state has to present to the grand jury. So at this point, when we're talking about grand jury proceedings, a probable cause bar, which is pretty low, honestly, probably lower than a lot of people want. We know the defense wants it to be beyond a reasonable doubt, as they made this entire argument going back to the beginning of time on why it should be beyond a reasonable doubt instead of probable cause. But at this point, with this type of a scenario, I would be surprised if the higher court granted permission and stayed the case.
Well, one thing we've got to keep in mind, although it's got a lot of publicity, this Kohberger case, there's a lot of things that make it sensational. It is not a unique murder case. It is just a murder case when you really think about it. And in every murder case, you challenge the grand jury, you challenge whether exculpatory evidence should go to the grand. These are not unique questions. There are also questions that can be decided by the trial. For instance, yes, they didn't present exculpatory evidence to the grand jury, but they're going to be able to give it to the regular jury that hears the trial. So it may become just a moot issue by the time the verdict comes around. So there's nothing unique here, and none of these motions are really unique.
Right. But I do think what makes it interesting partially is because it isn't secret. We don't know what it is. But judging off the other motions that Judge basically gave him a nice pat on the head, like that was a very interesting argument. Good job, but denied, and basically just denied everything. So if it was granted, let's say, and if they did get permission to do this appeal, pause the case, it would automatically create a stay. You kind of gave an example of a case that you had where the judge won't even look at anything because you can't do anything. No depositions, no expert testimony, no witness lists, no discovery. Everything is basically stayed in the case, which would create quite a delay. When you talk about interlocutory appeals, what is the timing? Because it's not years and years like a normal appeal can be, but it still is quite a delay when there's an appeal in the middle of the case.
Well, they normally expedite it in an appellate case because they know that there's a lower case, a trial that's actually sitting around waiting to happen. So they try to expedite these. You have a 14-day window to actually file your interlocutory appeal in Idaho. So there is an expedited process. So normally appellate courts look at this pretty quick.
But it's still a couple month delay, no matter how you look at it.
Oh, easily, because you've got first of all, you've got to file briefs. You've got to
Right.
get all the transcripts have
A
to be done.
response, a reply.
All the response, all the replies. Then you have to set it for oral argument. All that time, yes, it's easily months.
I do think they have all the transcripts, but I agree. That's easily going to be months. So the
Yeah.
state recently filed the scheduling order. They want to try this case in the summer of 2024. So, 6 months from now, if they grant this interlocutory appeal, just the permission to file the appeal, there's no chance it happens in the summer. I already think it's kind of slim to none that this case goes to trial in the summer. But if they grant this, if they get this permission, the chances go down to zero. Would you agree with that?
I agree with you. Absolutely.
Was there any other rules or stuff you want to talk about with the interlocutory appeal?
No, it's just like I said. It's Idaho's a unique situation, the way they do it, which makes it even less likely that it's going to be a successful.
And even if their goal was to delay, not high chances that it's going to be successful even to create a delay, let alone even if they grant permission, most appeals lose. And they don't want to overturn the trial court unless there's some fundamental error that occurred, especially in the middle of a case like this, knowing that if they grant it, they dismiss it, the state just refiles it, and we do this all over again. So they're human beings, and it would have to be something pretty bad for them to want to do all this over again, waste taxpayer dollars, waste time, delay the case, delay justice. The victims are going to be on their back. So what the law says is one thing, but also people are affected by what's going on, and practically speaking, what it would mean to grant an appeal like this, unless, again, there's something egregious we don't know about, fundamental error, first impression, something that's never happened before in the grand jury proceedings that we might just not be aware of.
Well, I think all of those things you say, slim and none.
Right.
Right.
All right. So let's transition here a little bit to the demolition. So I'm just going to play a little bit of JB's stream with no sound. So yesterday, they literally brought heavy machinery out, demolished the Kings Roadhouse, which was the crime scene of this case, and people are up in arms about it. My opinion on was, even if there's a 1% chance that this could become valuable in the future, I think just leave it up, especially if the trial might be in the summer. Maybe we just delay it 6 more months. It's not an individual's house. I think if it was a personal property of an individual, that would be different, and I could understand why they'd want to demolish it, or get rid of it, or not want to carry the costs or pay for it, things like that. But this is owned by the University of Idaho. It's public property, basically paid for by the taxpayers. I related it to the Parkland school shooting case where they kept the school up. The jury viewed it. The jury viewed the car in Darrell Brooks. The jury viewed Moselle in Alec Murdaugh. So there are some jury views in these cases. What do you think about them demolishing the house basically a year, almost to the month after these crimes occurred? What do you think evidentiary value could have still been there? Do you see any issues with it?
Well, I think there's two sides to it. The first side is again, you're talking the 1% chance, and I agree with you that in an abundance of caution, keep the house there until the case is over, just in case there's something, or just in case a jury view was needed for some reason that came up. But on the other side, The defense has had all the time they need to get all the forensic evidence, all the walkthroughs they wanted to do, gather any pictures, do anything, videos, anything the defense wanted to do. They've had sufficient time to do it. The prosecutor certainly has had sufficient time. They've gone in there with a fine-tooth comb and they've gone through every inch of the place, gathered all the evidence that's possible. However, again, why demolish it? There really, I don't think it was any real need to demolish it. I don't see a reason that it had to be demolished. Again, maybe there's something we don't know, but I don't see any reason to demolish it. I would have kept it for that 1% chance, even though I know there's only really a 1% chance.
Yeah, and I mean, I think it's fine to understand that it's not absolutely necessary, kind of like you said, and you can understand why because everybody's gone through. They've done 3D imaging of it apparently. So I understand all of that. But a couple of additional questions I have for you. Number one being, don't you think there is potentially some evidentiary value of, well, first off, let's talk about it both ways. So the arguments they're making, which I totally agree with, same thing happened in some of the items in Murdoch. The lawyer said it's substantially changed from what it was on the night of the crime. So that can happen because of testing. If they pulled up the carpet, if they pulled off the walls to test the blood, took the furniture out. So it looks completely different. So it wouldn't even be appropriate, or the defense would object saying, you can't get a good view of what that house was like. It's completely different. We don't want the jury to view it because it could skew what they view and what they think of the evidence and how things happen. What do you think about that argument?
Well, I mean, yes, the defense always doesn't want the emotion of the jury actually going to the location. We all know what that can do inside the jurors because you're while they're walking through there, they're remembering the testimony that occurred, and as they're walking through, they're looking at at this location that happened, at this location, and in their mind it becomes much more vivid than just sitting in a cold courtroom just hearing testimony because now they can really picture it. So the defense doesn't want that walkthrough. The prosecution may want the walkthrough. And here's what can happen. During testimony or during the defense's argument during the trial, the defense may raise something that the prosecutor never thought of, something about the location, something about we didn't see a drop of blood over here on the left, but we saw it on the right. Well, there could be a real reason for that. The prosecution never thought about it when they were doing their videotaping. And there's definitely could be a reason that you want the jury to go out and see why there wasn't blood on the left instead of on the right. Things come up during trials. Trials are, I describe them as living, breathing things. They're alive and things happen during trials. So you can't anticipate everything, which is one of the reasons why you might want to keep that house up in case something came up during the trial where you would need to do that. Or you would need to send somebody out there to take some pictures of a location since the defense raised something. You just never know what's going to happen during a trial. So you just can't prepare for everything. So that's why you probably should have kept it up.
And I think that it also brings into play like spatially, right? Even if the carpet's done, the furniture's gone, whatever, what could you hear on the third floor that you couldn't hear on the first floor? How far away is it? How many steps did they have to go up? You never know what a jury's thinking when they're walking through a jury view. And again, a lot of these things could answer questions for them that will be gone. If we both had to guess or put a percentage of who it benefited, it probably benefits the defense more than the prosecution to demolish a house like this and just remove a jury view from the question, because most cases where there are jury views, the defense objects to them.
Well, we've in Florida, unless a juror contacts you, we're not allowed to actually, talk to jurors. But I've had jurors call me, and I've been shocked at the things that I've had a juror say, we saw a picture in the kitchen. And we know while we were looking at that picture, we noticed that there were knives sitting here to the left, and there was a knife missing from the butcher block over on the left. That knife had nothing to do with the case. The butcher block had nothing to do with the case, but the jurors focused in on it. So you don't know what those jurors are going to focus in on, what they're going to see in a photo that you never saw. So that's why it's always nice to keep it around in case you needed it.
Exactly. And in all truth and fairness, we don't know. That's why we think about everything. We try to cross all the T's, dot all the I's, but you just don't know. And you don't know what's going to develop in the case, which I think is important as well. Last question about this. So they talked about doing 3D renderings. People have, said, oh, they should use virtual reality masks to let the jury, have some kind of interactive thing to walk through the house or whatever. what type of argument, because this happens in every case and people get annoyed at it, but criminal defense attorneys are going to argue against most of that. So what issues do you see with 3D renderings and virtual reality and letting the jury have a jury view without actually having the real jury view, best evidence arguments? If there's a measurement that's 1 inch off or 1 foot off or backwards or mirrored or whatever it may be, what type of arguments can you see the defense making to 3D renderings, virtual tours of the house, things like that?
Well, their arguments are going to be that they could be distorted, or that they could be manipulated. We all know. I mean, look, we're talking about AI now, and they're talking about this and how they could be manipulated, and you could see things that aren't there or create things that aren't there. There's always those questions of the authentication of the evidence. But I've got to tell you, all the things you're mentioning now, I think in a few years they're going to be commonplace in trials. I think that the jurors wearing those goggles in order to see the real-time virtual crime scene or recreations of a crime or recreations of a accident, those types of things, they're going to be everyday items in criminal courts. So I think we all need to get used to the fact that those things are going to come in, and the question is going to be authentication and making sure they are accurate and true and not manipulated.
And I think that is not going to be this case. I think that stuff is expensive. I think we're going to have rules around it, and we're going to have to talk about how to deal with it. I think the individual monitors and things like that will help, potentially virtual tours, but I think 3D goggles or glasses or whatever, virtual reality type of stuff, we're still pretty far away from that, I think, because it's really expensive. And I think it's going to have to become cheaper and more mass produced and easier to get and stuff like that. But I mean, I don't disagree. I think it is going to be part of the future, but it's a little bit scary because, we've had cases where the defendants swear the audio recordings have been edited or the video recordings have been edited. Could you imagine when they're allowed to recreate things as investigators in the state and put it on virtual reality goggles and we're allowed to watch it all at the same time, but then are they seeing the same thing we're seeing? And there's just so many issues that come up with that. But I think there will be a lot of discovery too, like depositions that happen, reports that are reviewed about how they created the 3D virtual reality images, how they created the recreation or reconstruction of the crime scene in this case, what they did, what measurements they used, where they got them, things like that. I think will all be something that we're going to have to watch and listen to. I don't like that view. Let me go back to this. That we're going to have to watch and listen to and see kind of how it happens in the future.
I'm sorry. I was just going to say, I know you talk about the expense, but normally the expense limitations are the defense.
Yeah, I know.
When you're talking about the government, especially talking about the federal government, because that's where this stuff usually starts, is by the FBI developing the technology to do this kind of stuff. They're going to have the money to do it. The FBI eventually is going to have an in-house group that's going to put this together, because I know, I've tried cases and the FBI has produced phenomenal exhibits, video. We call them, I refer to them as cartoons, but the recreations with stick figures of all this stuff, that used to be really unique at one time. But now the FBI does all that stuff in-house. So the federal government is going to start doing this, and then it's going to filter down into all the other types of cases and trials that we have.
Yeah. Yeah. And we'll see. I mean, I definitely think it's something that's coming in the future. Tech is definitely going to be used more and more in trials. We've always tried to stay on the cutting edge and ahead of the curve with that stuff, with iPads and presentations and being able to work on documents as you're walking through, and then everybody catches up. The state catches up. Usually the government's a little behind, in my opinion, than civil lawyers. Usually civil lawyers are on the cutting edge. They're willing to spend the money. They're willing to take the big swings. But I do think that a lot of it has to become admissible first. And sometimes with very new technology or weird or different, it has to go through the criminal process first. The government has to push it before the civil courts will even allow it in our trial. So we'll keep an eye on that stuff. I appreciate you coming on, talking about this stuff. Hopefully you guys enjoyed it. Hit that like button if you did. Make sure you leave your questions and comments on what you think about these situations and what's happening in this case. We appreciate you guys as always. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And Don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.